Computer Electronic Accommodations Program, highlights from Dispelling the Myths, Reasonable Accommodations under the Rehab Act, March 28, 2013. Jolinda Johnson, Director, Federal Training and Outreach Division, Office of Federal Operations, Equal Employment Opportunity Commission.
So, let's talk about what the Rehab Act requires. And actually, let me back up and ask, who knows what the ADA is? Only three of you, really? Are you lying to me? Okay. So, what's the difference between the ADA and the Rehab Act?
The Rehabilitation Act covers federal agencies, the EEOC covers the private sector.
That's right. So the Rehab Act covers the federal government, the ADA covers everyone else, private sector, state, and local. Okay? Which came first? The Rehab Act, and the ADA is actually based on the Rehab Act. So they are mirror images of one another. One just applies to a different sector than the other. So if you hear in the news that the Supreme Court made a decision under the ADA, it applies to us as federal employees in the exact same way. It just applies under the Rehab Act as opposed to under the ADA. Okay? So what did I do? There. What does the Rehab Act require? First and foremost, like all of the statutes enforced by the Commission, the Rehab Act says you may not discriminate against a person based on the fact that they have a disability. So there's a non-discrimination portion of the law. Everybody understand that? That's pretty straightforward. The second part of the law, and this is where it differs from other statutes that are enforced by the Commission, the second part of the law is that it says that in addition to not discriminating against somebody because they have a disability, you also, employer, you must provide reasonable accommodations to employees with disabilities. And we'll talk a lot about what that means, what that looks like, what it doesn't look like. It also requires that employers have, quote, an affirmative action program to hire, advance, and retain individuals with disabilities. Affirmative action, despite what you may think or may have heard, is alive and well in the federal government. It is not dead. Under the Rehab Act, federal employers are required to have an affirmative action program, and that's the actual language in the statute, and the statute is still in effect. So affirmative action is still in effect in the federal government, okay? The Rehab Act also prohibits employers from making inappropriate disability-related questions. This is an area where employers often find themselves running afoul of the law because they ask inappropriate questions at the interview stage, or when somebody's already on board, they ask inappropriate questions about whether or not they may or may not have a disability. So if I am interviewing someone, it is not appropriate for me to ask if they have a disability. It's not appropriate for me to ask questions that might lead to an answer about a disability or any sort of medical related issue. If I am interviewing for a position, I have to focus on what's required for the position. What are the skills and knowledge that is required for that person to perform. It's inappropriate for me to ask questions like, do you have any sort of injuries that I need to know about? That's an inappropriate question. Are you pregnant? That's an inappropriate question. That's an inappropriate question under a different statute. But those are the kinds of questions that we see more often than we should, but they're all prohibited. Okay, you have to focus on what are the job skills necessary to do the job, and does the person have them? Okay, questions about that? The Rehab Act also requires that employers keep medical information about all employees confidential. Take note that it says all employees, not just employees with disabilities, all employees. So this part of the Rehab Act applies to everyone. Whether I have a disability or not, I have a cause of action if my medical information is disclosed inappropriately. So if you have an employee who sends you an email saying, hey, I'm going to be out of the office for the next week because I sprained my ankle. Is that medical information? It absolutely is. It's innocuous medical information, and it's not the type of information that people are typically sensitive about, but it's still medical information. Therefore, it has to be kept confidential. As the employee who sprained their ankle, who sent that information, I can tell whomever I want because it's my information. You, as my supervisor or manager, you must keep it confidential. Okay? Does that make sense? A lot of times employers will think, oh, well, it's not like she said I was just diagnosed with depression. She just said I sprained my ankle. We don't weigh the sensitivity of the information. It's either medical information or it's not. Okay? Clear on that? Questions about that? Yes, ma'am.
So what about, okay, you say the immediate supervisor has to keep it confidential? What about the immediate supervisor?
The employer has to keep it confidential, period. That applies to everyone. All supervisors, all managers, everyone has to keep it confidential. Confidential, it can be disclosed to those who have a need to know. So what's an example of that? Let's say I am a person with a disability and I need an accommodation. So I go to my supervisor and say, I have a back condition, and because of my back condition, I need a different chair. The office chair that you provided me is not sufficient. Well, my supervisor has a right to ask for medical documentation to support that. Your employer has a right generally, number one. And number two, the supervisor is unlikely to be the person who's actually going to be buying the chair. They're probably going to turn that over to someone else who will do that. That person may have a need to know. So disclosing to that person might be appropriate. But disclosing to everyone in my supervisory chain, no. It's those who have a need to know.
A slightly different one.
Absolutely.
Let's say it's a friend of yours, I'm a supervisor.
Yes,
There's a colleague on the hallway who has an injury.
yes,
And, we work closely with other people.
Yes.
Not the same chain.
yes,
It comes back, they're out of the office because of this injury. That discussion comes to me.
Yes.
And I get the information, I know what happened. It's a particular issue. Now, because I'm a supervisor, you're saying, because I perceive that I need to hold that as being part of the employee, I wouldn't be able to share that with others just the way this group of people may be talking about it.
What do you guys think about that? Can he share the information or not? Remember my answer to her question.
I'd say no.
The answer is no. The answer is, there's two parts to this answer. Number one, supervisors and managers are the ones held accountable under this because you represent the employer. So if you are a colleague of this employee and you're just a line staff person, yes, you should keep it confidential, but we can attach liability to the agency for the behavior of a line employee in this instance. There are circumstances where we can't, we being the courts or the commission. In this instance, we cannot. But if you are a manager, supervisor, you're an agent of the employer, therefore you represent the employer, you are held to this standard. You keep medical information about all employees confidential and you only disclose it to those who have a need to know. So if there's someone that you needs to know, you can disclose it. If they do not have a need to know, the fact that you're not their supervisor doesn't change the fact that you are a supervisor. Okay? Other questions about that? Okay. The Rehab Act also requires that employers comply with anti-harassment requirements, meaning you can't harass somebody because they have a disability, and importantly, employers must address situations where harassment is occurring, even if it is based on disability. And you cannot retaliate against a person, number one, because they have a disability, or number two, because they have requested an accommodation. If I request an accommodation, I don't get penalized for doing so after the fact. Okay? Make sense? Questions? Okay. So, as I've mentioned, I'm going to go quickly through the definition of disability, because I think most people have a working understanding of it, but if I go through it too quickly and you don't understand or you have follow-up questions, don't hesitate to raise your hand and let me know and we'll come back to it, okay? So, a person with a disability is a person who, and this is a three-part definition, and it's important that all three parts are met. Number one, it's a person who has a physical or mental impairment. Number two, that substantially limits them in number three, one or more of their major life activities. So number one, physical or mental impairment. Give me an example of a physical impairment. Anything. An amputee, paralysis, what else?
Your bad back.
Bad back. What else?
Wheelchair, crutches.
Okay, so somebody who has mobility impairments. Okay, anything else? Vision, hearing. Those are all big ones. I'm thinking of small ones, like what if I sprain my ankle? Is that a physical impairment? Or break my leg, is that a physical impairment? I have carpal tunnel. Those are all physical impairments too, so large and small. Note that I didn't say those are all disabilities. I said they're all impairments because that's part one of the definition. So I sprain my ankle. Is that a physical impairment? Of course it is. Am I a person with a disability? We have to figure that out because we have to look at part 2 and part 3 of the definition, okay? So, part 1, physical impairment. What's an example of a mental impairment?
Depression?
Depression,
Traumatic brain injury.
TBI, PTSD,
ADD?
ADD, ADHD, dyslexia, learning disabilities, anxiety disorders, depressive
Seizures.
disorders,
Seizures?
seizures. Epilepsy, I think they are viewed often as mental impairments, but it really is a physical neurological impairment. Technically, scientifically, it's a neurological issue, but a lot of people believe it to be a mental impairment. Okay, so schizophrenia, bipolar disorder, depressive disorders, anxiety disorders, learning disability, learning impairments really we'll say. Any number of things could be a mental impairment, any number of things could be a physical impairment. Doesn't necessarily mean if I have that diagnosis that I'm a person with a disability yet, because I still have to go through parts 2 and 3 of the definition. So you with me? Okay. Part 2 says that whatever that impairment is, it has to substantially limit part 3, a major life activity. So let's go with part 3 for now. What are examples of major life activities?
Dressing yourself?
Dressing yourself, caring for yourself is what we would call that, yep. What else?
Birth, when you were born,
Being born?
being born.
No, we wouldn't call being born a major life activity, but think of it this way. Major life activities are things that the typical person does as part of a typical day in a typical life. So what do you do every single day?
Eating, walking, breathing,
Walk, eat, breathe,
Dress.
sleeping.
sleep.
Drive?
Driving is not a major life activity.
Talking?
Talking, thinking, concentrating, learning, communicating, caring for oneself.
Working?
Working is a major life activity. Driving is not. Traveling is not. Keep that definition in mind. Typical person, typical day, typical life. So in DC, everybody drives. In New York, nobody drives. So it's typical person, typical day, typical life. That's why driving is not a major life activity, because it's geographical. What else?
Bodily functions?
Bodily functions. Eating, digesting, eliminating waste. What else? Normal cell growth, all the major functions of your internal systems, so normal respiratory systems, normal immune system, the functioning of all those systems are all considered major life activities. So putting those two together, 1 and 3, to get to the definition of disability. I have to identify a physical or mental impairment that substantially limits me in 1 or more of those major life activities. Part 2 of the definition is those major, substantial limitation. What does that mean? It means that you have some difficulty in doing it. It doesn't mean that it's impossible, doesn't mean that you can't do it at all, but it means there is some impact on your ability to engage in one of those major life activities. So, if I'm a person who has been diagnosed with carpal tunnel syndrome, but it was a sort of an ancillary diagnosis as part of my yearly physical, and when my doctor says, do you have problems, with the keyboard, do you have problems operating small items like this remote, and I say, oh no, I may have carpal tunnel, but I wouldn't have known it if you hadn't told me. I have an impairment, but it's not impacting any of my major life activities. Am I a person with a disability? No. What about, compare that to another person, same diagnosis, carpal tunnel syndrome. They have trouble keyboarding, they have trouble holding small objects, they have trouble typing for more than 5 minutes at a time. Might that person with the same exact disability, or same exact impairment diagnosis be a person with a disability?
Yes.
Yeah. All disability decisions are made on a case-by-case basis. It's made on an individual-by-individual basis. You can have 2 people with the same impairment diagnosis. One person is a person with a disability, one person is not. It's absolutely possible. Let's use my broken leg example. It's a physical impairment, yes. Does it substantially limit me in any of my major life activities? Which one? Walking. What about the fact that it only lasts for 6 weeks? Maybe, if it's a a small break, and I'm only gonna be in a cast for 6 weeks. Does that mean I'm not a person with a disability? Or does it mean I'm a person with a disability for 6 weeks? I'm a person with a disability for 6 weeks. Now, if you've ever had disability training before, this is different than what you used to be taught, because what changed? In 2008, the Americans with Disabilities Act, Amendments Act, the ADA Amendments Act was signed, went into effect January 1st of 2009, and some say reinstated the intent of the law all along, I being one of those some, because this is what it used to mean, and then the Supreme Court narrowed it, and the ADA Amendments Act came back and said, no, that was not the intent. The law means substantial limitation was broadened so that who is considered a person with a disability could be much vaster than what it used to be. And so you will have, is vaster a word? I'm gonna have to think about that. More vast. I might make up some other words as we go on. Who might be considered a person with a disability is much broader now. And that was the intent of the law all along. The ADA Amendments Act sort of reinstated that. So a person, it used to be, when I taught this class, to managers and supervisors, and we were talking about a person with a disability, I would use the broken leg example as an example of a person who was not a person with a disability. Now, it is my example of a person who is a person with a disability. Even though it's a temporary impairment that's gonna be fine in 6 weeks, at the end of those 6 weeks, I'm no longer a person with a disability. But for these 6 weeks, I am. And what's significant about that is that means during those 6 weeks, I might be entitled to an accommodation. And the agency might have to accommodate me for 6 weeks. And then when the cast comes off and everything's healed normally, then they get to revoke that accommodation because I don't need it anymore because I'm no longer a person with a disability. Make sense? Questions about that?
Don't like the same thing if the person has a sciatic nerve problem.
Yeah, if you have an episodic condition, so it flares up, it might be a sciatic nerve, it might be epilepsy, it might be cancer. You have things that come and go. When they exist, I'm a person with a disability. When they go, I might not need any accommodation anymore. So we might have accommodations that only occur periodically because you only have a need for them periodically. If I'm a person with epilepsy, let's use that as an example. I may need accommodations of when I have a seizure, I'm gonna need time off, and I may need unscheduled time off. I'm not gonna be able to give you a week notice. I had a seizure yesterday and I'm gonna need 3 days to recover from that. That's the accommodation. Leave is a typical reasonable accommodation, and that might be what I need. But I only need that unscheduled leave when a seizure occurs. Otherwise, I will be able to tell you ahead of time that I wanna take, next Wednesday off or something like that. Okay? Other questions? No? All right. We talked about the ADA Amendments Act. Importantly, if you have managers who've had training before and they're having a hard time sort of making the transition after the Amendments Act, what it helps to remind them of is that the intent of the law is not to focus on whether or not the person has a disability. And there's a lot of language in the actual statute, there's a lot of language in the legislative history of the Amendments Act that goes into, look, we don't want employers spending all their time combing through medical information to figure out whether or not a person is a person with a disability. What we want you to spend your time on is figuring out how to accommodate them. If you've got information, sort of minimal information that's enough, that's all you need. You don't need to go through this rigorous test to figure out whether or not they're a person with a disability. Focus your energy on how do we accommodate them, okay? Questions?
Yeah, isn't the last slide with record of disability?
Oh, yeah.
What constitutes a record?
You can replace the word record with history, and that might make it easier to understand. I can't be discriminated against if I have a history of a disability or a record of a disability. Record is little r here, not capital R, record. Record meaning, let's say I had a heart attack last year, and everybody in the office knows that I had a heart attack because I was out for 6 weeks recovering, you sent me flowers, you sent me a card, it's not a secret. There's a history of a disability there. That's what that means. If I have a hidden condition that nobody knows about, but my manager and the disability program manager, because I submitted documentation because I wanted an accommodation, there's a record of that too, at least with those people. Okay? Make sense? Other questions about that? So I didn't go into those second bullets because I'm focusing mainly on if you are a person who currently has a disability and has a need for an accommodation. And because this session is about accommodation, I'm not really talking about the last two. The reason why I'm not talking about the last two is because if you're a person who doesn't currently have a disability, you're not entitled to an accommodation. You are entitled to protection from being discriminated against if you have a history of or a record of. You're protected from being discriminated against if you are being regarded as a person with a disability. But our focus is on who's entitled to reasonable accommodation, and it's the person who has a current impairment.
This CAP Dispelling the Myths program showcased key highlights of the featured speaker, Jolinda Johnson. CAP thanks Ms. Johnson and EEOC for sharing valuable insights regarding reasonable accommodations under the Rehabilitation Act. To learn more, visit eeoc.gov and cap.mil.